Hearing the appeals in the matter of HW children and HW children are two.
Before we commence, I should indicate that the court has made an order that no one shall publish or reveal the name or address of the children who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the children or of any member of their family in connection with these proceedings. Yes, Mr. Mark.
My Lord, my Ladies, I appear on behalf of the first appellant in this matter with my learned juniors Miss Makepeace Grieve and Miss Izzard Hobbs. I'm instructed in this matter by Miss Sarath Chandra. I know that, my Lords, my Lady, you have the list of all the other advocates and representatives in the courtroom, so I'm not going to go through them all. May I also say that this morning present in court are the children's mother and the adult child B. I thought my Lord, my Lady ought to know that.
Thank you.
In this case, of course, the court is concerned with 3 children, C, who is age rising 14, born in 2008, D, aged 11, born in 2010, and E, aged 8, born in 2013. My Lords and my Ladies know from the background summary and statement of agreed facts that they are 3 of a sibling group of 6. And we will refer to them throughout by the initials on the alphabet, which I hope my Lords, my Lady, have. The issues in this case, my Lords, my Lady, notwithstanding the handout, which of course took us all back slightly when we saw the issue there, which is different to the one for which permission was given. So anybody that may have read that, the issues and the permission was as set out in the permission given by the 3 Lord Justices. In making care orders for the removal of 3 of the first appellant's children into foster care, question 1, in order to decide whether those orders were proportionate, was it necessary as a matter of law to assess the likelihood that if left in the first appellant's care, the children would suffer sexual harm, the consequences of such harm arising, the possibility of reducing or mitigating the risk of such harm, and the comparative welfare advantages and disadvantages of the options presented. And question 2, did the judge err in law by failing to make any or the proper assessment of those matters? The other issue that is touched upon by all of us, which is the issue that was picked up in the summary, is when an appellate court reviews a first instance decision concerning the proportionality of orders made under the court's obligation under the Human Rights Act 1998, is it necessary for the appellate court to undertake its own proportionality assessment of that decision? So, my Lord, my Lady, it wasn't an issue for which appeal was given. We have all trespassed on it because in some ways it links to question 2 to some degree. Save as is set out in our skeleton argument, unless my Lords and my Ladies want the first appellant to address that any further, we don't intend to, because it's not a matter on which permission was given. So, my Lord, as I said, the 3 subject children are a sibling group of 6. It is important in recognising the issues in this case that the appeal concerns care orders made by His Honour Judge McPhee on the 26th of July of last year. All of the children, save for the 2 oldest children, A and B, who now live independently, remain at home, as they have done throughout all of their lives, in the care of their mother and the care of the second appellant, who is the biological father of F, the youngest of the sibling group, but also a psychological father of some of the other children, and certainly those with whom the court is concerned. The background...
Coming back to the two issues,
yes.
I think it's fair to say that everybody's in agreement that the answer to the first question is yes. Is that right?
Well, my Lord, my Lady, yes, and I was going to ask how far and to what degree my Lords and my Ladies wanted me to go through and summarise those issues, because I think it's safe to say that between the skeleton arguments you have, we have probably said between us everything that could be said about the question in respect of number 1, and all of us say resoundingly yes is the answer to that question.
For my part, it would certainly be helpful to look at question 1 so far as it impacts on question 2.
Well, my Lord, yes, because of course that's the central issue of the appeal. Well, my Lord, may I just set out why that question is important in looking at question 2? And if I may just stand back a little bit and look at the importance of that in care proceedings generally, not least the proceedings for this family, my client, and the children for whom the court's concerned. The decision whether to make a care order, in particular where the care plan is one which sees long-term separation of children from their parents, is one, and it has been said in many judgments, of the most draconian orders that the courts of England and Wales can make. The interference in the rights of both the children and those of the parents and the family are significant, long-lasting, and one might even say life-changing. And whilst it's right and important for the courts of England and Wales to have in place a system of child protection which provides for these lifelong protective measures, we submit that the insurances contained not only within Section 1 of the Welfare Checklist of the Children Act 1989, but also the Human Rights Act, are important and significant. And the consideration of the import into the Children Act 1989 and the principles and language of the Human Rights Act, so the principles of necessity and proportionality at that very last stage of considering whether to make a care order, dealt with in detail in all of the jurisprudence we've set out for you, but it shows how significant and important it is. And it's language that both Lord Wilson and Baroness Hale in the case of Re B made plain had been considered right from the beginning of the drafting of the Children Act. And of course, Baroness Hale in Re B was able to tell us that because she was part of the drafting committee and sat on Re B. And of course, she deals with that at paragraph 194 of Re B. It's also important in looking at question 2, my lords and my ladies, to think about these policy issues that my learned friend leading counsel for the local authority raises, and of course we've all dealt with in our skeleton arguments. And it's important because we are at the moment in the family division working with a significant number of cases, and my lords and my ladies will be aware of the guidance from the President, Sir Andrew McFarlane, that has come out recently and as long ago as 2021, called The Road Ahead. And that is necessary at the moment, not using the word necessary in a wrong position here, but it's necessary to have that because of the significant number of care cases that are in the system at the moment, as well as private law proceedings. And of course, the Public Law Working Group only last year, under the guidance of Mr. Justice Kean, looked keenly at how we could manage all of these care cases so that the system from the local authority and the first social workers on the ground all the way through to these final decisions could be managed in a way. And the law, though, is plain that none of that guidance, none of the language of the road ahead dilutes those very last checklists that are undertaken by the judges. They don't dilute the application of the welfare checklist. They don't dilute the import of the Human Rights Act and the importance of it. How a case is managed and the correct way of looking at the evidence, whether experts are necessary, is one thing. The correct application of the final checklist at the end of the proceedings is another. And there's nothing in the reading of the road ahead or the guidance that came out last week, which we didn't put before my lords and my ladies because you have a lot of paperwork already, and it is very much the same language and just reminding everybody in the system to look with care. All of that language just is about managing the system. It does not dilute that final test.
Well, Ms Markham, does this case not come back to the point that you've identified really, which is substantive? I mean, what you have in this case is a judgment on threshold,
Yes.
which nobody takes any issue with the factual findings. So it's when you get to welfare stage, which is what we're looking at, how the judge has effectively applied the welfare checklist and in parallel the Article 8.2 proportionality exercise that's required. So, I mean, if we go back to the first of the 4 questions identified by this court, is there any real dispute about the first issue, which is in relation to sexual harm, likelihood of left employed to suffer sexual harm, given the findings already made?
Well, no. I mean, save for the language perhaps that His Honour Judge McPhee used, is that it may occur.
Yeah.
But we're not in the approach to this case taking issue with that, as I think we've been clear to say. It's the evaluation of all of those findings at the end that we say was lacking in this judgment.
So, in relation to harm, the checklist obviously requires you to look at harm.
Yes.
So he's done that.
Yes.
He's referred to it. There's a finding already made in relation to it. So arguably there's not much purchase in the in taking any issue with the first question posed by the court.
No.
Or in fact potentially the second question, which is the consequences of
so the second within one, sorry, not the second main question.
the second
Yes.
within one.
Yes,
Yeah.
yes. No,
Right.
no. I think all of us agree that between us are the advocates.
So where are we in relation to the third and fourth aspect of 1?
The comparative welfare advantages and disadvantages of the options we do highlight,
Yeah.
because we say that that is the focus of where we say the learned judge erred and failed to consider all of those welfare advantages, disadvantages and the options. And perhaps standing back, it's looking at the 6 questions that Lord Jackson poses in both Re K and Re F that we've set out, various of us, during our submissions. It's those 6 questions that we say can't be found in the judgment if you look for those questions and therefore the answers to them. And absent those questions and absent the answers to them, the final point of my Lord, my Lady is point 1, which is the comparative welfare advantages and disadvantage, and of course the possibility of reducing or mitigating the risk. You can't find the answers to that.
So it's C and D. It's
C
not
and
just
D.
D you're addressing. As I understand your submission, you are saying that the learned judge has not spelled out properly his position on C and D.
Indeed, yes. And it's a somewhat narrow point, but it is so very important. And we don't take issue with the fact that this is a lengthy judgment. It deals with a good summary of the evidence. We accept, as my learned friend for the local authority says, that at the beginning of the judgment, His Honour Judge McPhee sets out what he's got to do. But what we say is by the time he gets to paragraph 162 of his judgment, if I may just take my Lord, my Lady to that.
Yeah.
For an example, if you look at paragraph 162, and that is at EF 284, electronic page, I think 285, they're one ahead. And this is where the learned judge is going through the welfare checklist. He says at paragraph 162, the last issue to look at, the ability of each of the parents and their capability of meeting their needs. Well, it wasn't the last issue. It was way before the last issue. And there were 2 more questions, at least in the welfare checklist, for His Honour to ask himself. And there were, of course, then the arguably additional questions that Lord Jackson identifies in Re F and Re K, which is the evaluative judgment. But not just the evaluative judgment in relation to the totality of the
Can I
evidence.
just stop you for one minute?
Yes.
I had rather understood that one can see the first instance judge looking at the first 6 of the 7 in the checklist. But you say, as I understood it, And I found what Lord Justice Peter Jackson rather helpfully did, which was to put the headings
Yes.
for the different paragraphs. It was simply the seventh of those that was missing, the range of powers available to the court under this Act in the proceedings in question. Is that not right?
Well, my lord, I think we're slightly talking. There are two checklists that I'm referring to. The first is the welfare checklist,
Yes.
A to G,
Yes.
and of that G, we say and accept is missing.
Yes, thank you.
But there are also the 6 questions that Lord Jackson identifies on proportionality in Re-F and Re-K.
Right. Where do we see those, sorry?
They are at EF 1380. No, that's that takes you to the beginning of the judgment. My apologies.
It looks like Re-F wasn't actually referred to His Honour Judge McPhee. Is that right? There's some reference to that, I think, in Lord Justice
Yes,
Jackson's
it is right. It wasn't referred to him. Yes.
Sorry, which case are we now looking for?
This is Re-F at
This is Re-F.
1380.
And I've now got the wrong reference to it, so it's probably the first of many. My apologies. Thank you. It's at
Is it
page
1382?
1381. Apologies. I've got my authorities on a different link, so I'm just going to them.
Yeah, 1381.
Does my lord have that page?
Yes, thank you.
And so you can see those are the other 6 questions that we say are linked to the welfare checklist, but also stand...
I'm sorry to interrupt. Should I be looking at 1382?
1381, my lord. It is paragraph 2 of...
Yeah, got it. Okay, thank you.
And again, you can see where there are the links to the welfare checklist, but they're not the same as the welfare checklist. And in our skeleton argument, we have looked at the Bank-Mellett test against these same questions, because, of course, that being the proportionality test. And we say they are the same questions, but couched in a family framework in terms of risk of harm and mitigation of risk.
Well, there's a danger in having too many questions, Ms Markham, it seems to me. Surely these are aids to answering the requirements under the welfare checklist.
Yes.
Because otherwise you're going to have confusion. They don't do anything different from what's required by the welfare checklist, it seems to me. And your point, as Lord Burrows has identified with you, is that G is left out by this judge, you say, which is the range of options, which is looking at the least interventionist order, I would have thought, on your case. So I'm back to, is it not right that really what we have is statutory checklist, other tests under the Children Act and the Article 8 consideration? These are aids, these are questions by way of aid to help you answer, I think.
Yes. Putting it differently, they are aids to help a judge, particularly a hard-pressed judge, who is having to manage cases in the current climate, to have as an exercise to go through. And when they get to G of the welfare checklist, they turn to these 6 and they ask themselves all of these questions with respect to each of the children. So you don't just do it in respect to the family group. You stand back and you think about the first child and you go through these questions. You think about the range of options. You think about the various risks of harm to each of the different children. So, for example, in this case, although F wasn't a subject of the considerations in the final care orders, the considerations for F of a certain age and the risks of harm are going to be different to those for C of a nearly 14-year-old. And that's why the court has to go through each of them differently. So yes, my lady, I would agree that these are a helpful tick box exercise for hard-pressed judges to go through, because we would submit that if a judge going through the welfare checklist then pulls out these 6 questions, goes through them, and that is plain from a judgment, no matter how short, they've done their job, and you can see they've done their job.
Yeah.
Mark,
Can I just
is the issue really
add
going to boil
there
down?
that my understanding is that the first question that we have been, on which permission to appeal has been granted, is based on those factors in Re-F that Lord Justice Peter Jackson has articulated.
Yes.
So that I think we'd agreed, or rather your submission, as I understood it, was clear that you were really challenging the 3rd and 4th
Yes.
of those in the question that were posed. And we really don't need to go back to talking about which factors in Re-F in a list of 6, because it's already been more concisely put forward, and we're now talking, I think, about your submission being that 2 of those have not been properly looked at, as I understand your submission.
Well, that's absolutely right.
Yes, thank you.
And the mention in Re-F at 6 proportionality, that is built into C and D.
It is.
In the four tests that are there listed in question 1.
It is, my lord, and it's whether or not this court agrees that those additional 6 questions are helpful as a tick box exercise for a judge in undertaking the judgment and the analysis, because it keeps you focused, it keeps you mindful of those evaluative options, the comparisons, the questions one must ask. My lord, my lady, I thought that Lord Hughes was speaking, and I would pause in case we didn't hear earlier.
Well, that's kind, Ms. Markham. I was only going to ask whether it's your submission or whether you agree that in the end this looks as if it's going to boil down to whether the correct approach, whilst not explicit in the judge's judgment, is inevitably implicit. You say it isn't, and the local authority, as I understand it, says it is. And it's an argument, perhaps, is it? Which is sometimes described as the difference between a criticism of substance and a criticism of form. Is that where we're going to end up?
It is, and my lords, my lady, I confess that in preparing for the submissions to be made today, it seemed to me that with all of the lawyers involved agreeing the principles in question 1 and the law as we all do, that it did boil down to almost an old-fashioned appeal as to form and whether or not we say the first instance judge ticked all of the boxes. But that's no less important for the family that are here. And my lord, my lady, of course, this being the most senior court, to review and reflect upon all of the jurisprudence that has been put in place and has come about since Re-B, whether or not there has been a tendency to overcomplicate the questions, to add in too much guidance, and whether or not it is important to remind everybody, as my lord did, that actually we are just looking at the welfare checklist. And as my learned junior, Miss Makepeace-Grieve, reminded me only yesterday, it's section 1 of the Children Act. It's 1 because it's there. It's the most important part of the Children Act. Perhaps that is why this case is important. It is a timely reminder when judges are really quite hard pushed and are overworked, and we have come out of a 2-year pandemic and are in recovery, that whatever the approach, however brief a summary of the facts or a summary of the evidence is heard, an appellate court undertaking a review, or perhaps even more importantly, a parent reading the judgment, must be able to identify within the judgment that each of those components of the welfare checklist have been considered with reference to the evidence and with reference to the evaluative checklist in respect of each of the individual children. And so in this case, my lords, my lady, if I may then move on to some of our submissions in respect of the judgment. I'm going to repeat myself slightly because I think I've said some of these matters. We say that in this case, and I'd already taken, my lords, my lady, to paragraph 162, is that that is where the learned judge falls into error. He forgot about the last bit of the welfare checklist. He doesn't, when he's looked at the harm, he's looked at the capability of meeting the parents, he doesn't look at the possibility of reducing or mitigating the risk and the comparative welfare advantages and disadvantages, which are all then encompassed under the range of options. Because when a judge stands back and thinks about what options do I have before me when I'm looking about managing an identified risk, you have to think about how within those options the risk can be mitigated, the capability of the parents to work within any of those structures. So, for example, in this case, the use of a supervision order. And the use of a supervision order in a case when 3 of the children are of an age that, with renewals of supervision orders for 3 years, would take at least 2 of them to an age where they would be well beyond the necessary safeguards. One of them, of course, I accept, the younger D and E, perhaps there, but certainly for C, she would be 17.
The age being 16, is that right, or 17? What is
Well, 17 is the age by which a care order can't be made. Usually one isn't made 16. But of course, we're looking at safeguards and moving away into foster care away. The older a child gets, the more the risks and disadvantages there are. So looking at the safeguards under the supervision order, and equally looking at the way in which the injunction has protected the children. And so, of course, there's been an injunction in place, I think I'm right, since March 2020. So for 2 years now, and that injunction was made by Her Honour Judge Mellenby when the case first came before her. And there has been no evidence, and there was no evidence in front of His Honour Judge McPhee of any breaches, either by A, or more importantly, by the mother and the second appellant. And one can...
Have we got the terms of that injunction?
Yes, my Lord, you just get the reference from my lords.
Thank you.
And of course, the other important factor is that risk isn't just the identified risk. It's the risk of harm. It's the balance of harm. So when you're looking at range of options, the court must look at the range of options for each of the children. What are the risks for child D of going into long-term foster care? Why has the mother, in her final submissions, made a heartbreaking decision to submit to His Honour Judge McPhee? If you really think I can't manage all of the children, at least think about this child remaining at home with me because of this child's particular needs and issues. But my lord, there's no reference to that. When you read the judgment, you wouldn't know that that was a submission made to His Honour Judge McPhee because there's no reference to it.
Well, I rather thought, if you have the judgment there,
Yes.
If you go to paragraph 142 of the judgment, and there's this, this may be out of sequence, and that may be a problem, but from 142 to round about 145, at 142, the judge starts by referring to available options.
Yes.
So then at 143 refers, it seems to me, to the case made by the appellants. Also refers to some focus on the differences between the children at 144, and at 145 refers to a supervision order or a care order. So does that not cover this issue implicitly in terms of range of options and looking at what could be provided under the different public law orders here?
Well, My lady, the local authorities say yes, it does.
Yeah, but that section, I think,
It is
probably
particularly
where
that
the-
section,
Yeah.
and they draw that out. But, my lady, we say no, because that was where His Honour was directing himself that he needed to do it. But where did he then go on and do it?
Where does he mention the injunction or the non-molestation in terms of an ally with the supervision order?
He doesn't.
Right.
The non-molestation order, my lord, my lady, is at EF 792 of the bundle, for your reference.
So just to be clear, if you don't mind, from my point of view, you say the judge set up the right questions, in a sense, from 142 to 145, but then didn't analyse them where he should, coming
Indeed.
towards the end of the judgment. Because
Indeed.
he stops at
160,
E,
yes.
or F, actually,
At F.
and doesn't go to G then.
Exactly,
Right.
yes. To be fair, he mentioned supervision at 145,
Yeah.
but the question was specifically where did he mention it in relation to some or all of the children and in conjunction with the injunction, and he doesn't. It's the two together.
Okay.
Because, of course, he directs himself again. They're not particularly concerned that an order would maybe imposed upon them, whether it be a care order, which would be unlikely for children to be left home, or a supervision order. So they're setting out what the family's case is, but doesn't then himself look at the comparative risks of that.
And I think you're also making a point that he should have done that for each child,
Yes.
given their own particular circumstances.
Yes, and we say that that's important, because the welfare checklist isn't just a welfare checklist of the family, it's a welfare checklist of each child, because when one looks at the welfare checklist, that must be right, because the educational physical needs of child A, I'm using not the children in this case, of child A, for example, or child X, may well be different from the physical and educational needs of child Z in any family. And of course, it's also important to look at, I think I've already said this, the difference in each child, because the risks are likely to be different. So the risks which His Honour didn't look at, and you can't find it in the judgment, because he didn't he didn't express that he had thought about it, and therefore we would say that on review, one can't be sure he undertook the assessment. He didn't think about the balance of harm for each of the children. There's no reference to that, and that's the comparative evaluative approach. We do say that because in this case, His Honour undertook a value judgment. He uses language that mother's behaviour was unforgivable. And perhaps that stuck, and he wasn't therefore able to stand back and undertake the comparative evaluation in respect of each of the individual children. And of course, in our skeleton argument, we have aligned ourselves with the approach that Lord Jackson took in respect of those particular, he says, were deficits in the judgment. And of course, we would align ourselves with those in this court. And the reason that's important is because not only on proportionality, but under the welfare checklist, the global holistic evaluation is that last checklist. G is really important because it is the court's last checklist. You stand back and you think, well, I've looked at all of these issues in respect of each of the children. And so that I don't undertake a linear approach, which, of course, my learned friend, Mr. Tyler Queen's counsel, on behalf of the second appellant, says that this is a paradigm case of a linear approach. But so that you don't do that, G is very important. So you think about the range of options, not just A and B, but what else is there out there? And it might be said to look at it a different way. The courts really are only pushed into that final decision and the state's intervention to remove children from their families because there's nothing else you can do. That's a phrase that has been used time and time again, but it's a straightforward phrase. The court doesn't set out to say, well, I know at the beginning that I'm going to make these orders. The court finds itself compelled to make those orders. It's compelled to interfere with the Article 8 rights because there's no other way to keep the family together. But you can only get to that point if you've thought about all the other ways that might work and say, it's with a heavy heart. I've gone through A, I've gone through B, I've gone through C, I've even looked at D, and I just can't see how that would work for each of these children individually and separately. And there are cases, reported cases, where having gone through those checklists, decisions are made where some children are separated and others aren't. And in this case, we submit that standing back and reading this very lengthy judgment, there's a lot of information. There's a lot of assessment. There's a lot of review of the evidence that was heard. But when we get to the final analysis, you can't see those questions being asked. And again, the other point in the judgment that we say is a clear indication that His Honour didn't undertake G. It's paragraph 169. Because if you read, and as my lady pointed out, the self-direction that starts at possibly even 132, because that starts at the top of the welfare checklist, but particularly that final bit, and then you think about where the learned judge gets to at 162, which is the last issue. At 169, he says before any discussion of any comparative analysis or thinking about the individual needs of the children, so I determine that for those reasons, it would not be safe any longer for the children to remain in the care of Mr Nevis and Miss Holtham. He's made his mind up there. So it's almost reading between 162 and 169. Where is the final part of the welfare checklist considered? It's just not. Because then, of course, the paragraphs that follow are looking at one of the other father's cases in respect of one of the children. It's odd because paragraph 174 and 173 and 174 look at what foster care might mean for the children, but it's too late by then because the judge has already told us he's made his decision.
Mrs. Markham, this is an extemporary judgment, isn't it?
Was it extemporary? Yes. Yes.
No doubt with notes, of course, but it's an extemporary judgment at the end of a 6 days hearing, some of which has been virtual and some has not. You're almost bound to get things out of order from time to time, aren't you?
My Lord, yes. And even if, my Lord, then you could say, well, Miss Markham, what about what he says at paragraph that come after? Then perhaps we would have less force in our submission. But my primary submission is that I, as Lord Jackson did, standing back, ask my lords and my ladies to find in this judgment any reference to section G, save where the learned judge identifies that he's got to think about it. But identifying that you have to think about it isn't the end. That's the first step. How did I think about it with reference to the facts of this case and to these children sufficiently enough that the family know and can see what the learned judge did and that an appellate court on review can see? And it's looking at the position that Lord Justice Leveson took at the Court of Appeal in his brief consideration of the review. He said, I can't really tell if he was right or wrong. Well, my Lord, my Lady, I would submit that if you can't tell if a judge is right or wrong, then you need to ask yourself, why can't I tell if the judge was right or wrong?
That's not what Lord Justice Lewison is saying. Not at all. He's not saying he can't tell. He's saying the decision could have gone either way. But well, I understand your more fundamental point, yes, which is that you can look at this, you can look and see whether explicitly or even implicitly the judge has ever said to himself, is there a way of reducing the risk? Is there a way short of taking the children away? How do I balance the dangers of taking them away against the dangers of leaving them where
Yes.
they are. That's how you put it, isn't it?
It is, and I probably find myself repeating that argument, hoping that it would have more force each time I said it, but I don't think I need to. We deal with it in our skeleton argument, and we have set out in some detail why we say, and again, we've adopted what Lord Justice Jackson said. Just for the reference, it's at EF 248. And he notes the absence of the range of options. He says it's entirely missing. And whilst, again, my lady has properly taken me to paragraphs 134 to 147 and 148, where the local authority say you can find it, we say you can't. We also say at 176 that he doesn't deal there, again, where he could have done, why he had found the care plans were necessary. He says, I've carefully considered the local authority section 31A plan for the placement in foster care under care order. It seems to be necessary so as to allow the children to be cared for in foster care. But why? Why was that necessary as set against the proposals of the mother and the second appellant? And you can't tell.
Well, I think the local authority says, doesn't it, that the last sentence, which you've not read for the moment at least, it's the only way, is the judge addressing whether there's any lesser alternative.
Well, they would, because they would want to say that. And I hope I have identified why that would be wrong in this case. It's a bit like the sandwich without the filling. There's the dressing at the top and the dressing underneath, but in the middle, it's difficult to know what were the ingredients. How did the judge pull apart the different needs of the children to come to that conclusion that it's necessary? There is a risk, and in many cases there are risks, but it's whether the risk can be mitigated and must be balanced against the risks that will exist of the children being removed for the rest of their minority into alternative placements. And we know the risks were there because, of course, and I hopefully somebody will help me with the paragraph in a moment, and the learned judge says, well, of course, I need to bear in mind that the foster placement might not succeed. I don't exactly know where the children are going to be at the moment, but it's all right, they'll just move to another placement. Well, we say that wasn't good enough, not within the welfare checklist. That's why the welfare checklist is there.
Just sorry, when you're still on 176, is that not a core part of this judge's analysis? Because what he says there is, and bear in mind he's heard evidence, including expert evidence, extensive social work evidence, he's heard from various other witnesses. But what he comes down to there is the need for the local authority to share parental responsibility. So the only way a local authority can share parental responsibility is by virtue of a care order. They can't do it under a supervision order or with anything else. So is that not a kernel of reasoning here which relates to capability, protectiveness of the caregivers?
But of course, care orders can be made with the children remaining at home.
No, I know.
So I'm being told that it was also a proposal made. So even if the learned judge decided that parental responsibility needed to be shared, there was still another way of holding the family without separation.
So perhaps you don't, say for argument's sake, you don't take issue with the need to share parental responsibility, for argument's sake. The judge should then have considered, well, can that be dealt, can the children all be maintained together, which is an advantage rather than separate foster placements, at home under a care order, or before even having to go to the other options which don't allow for PR?
Yes. I would say there was a stage before. You asked me in the proposition, the hypothesis that we accepted the need to share parental responsibility. Yeah. We say before the learned judge got there, he ought to have looked at supervision orders to see what safeguards could be in place with a supervision order and what supports could be put in place under that statutory provision with the injunction in place, to then say, I've thought about that, but even with all of those in place, and he could have, for example, asked the local authority to produce a supervision plan. How are you going to manage? What will you do? How often will you see the children? And could have thought about other injunctions that could have been in place, a whole range of options, the range of options, and then gone through them and said, I've considered this, I've considered that, but for all these reasons, I still think that the local authority needs to share parental responsibility. Step one. Then the learning judge needs to think, having got to that point, can the children remain at home under a care order? And what is the balance of harm and the risk of harm of the children remaining at home with the local authority under care orders? And quite often we hear judges saying, well, that means children need to remain looked after children with all of the intervention, but that's going to happen if they're in foster care. So all of that kind of dialogue that one might have thought about seeing, particularly in a judgment of this detail, is missing. So that's why we say 176, as Lord Jackson said, was the kernel of it. You don't know how the judge gets to that point in time, because the range of options wasn't considered.
In your written case, do you actually set out the range of options that you would have expected to see?
I am not in a list, no. We deal with it in the substance.
Right.
But certainly in the oral submissions that were made to His Honour Judge McPhee at the conclusion of those five days of evidence concluded,
Right.
they were set out.
Speaking for myself, I don't know whether others would think the same, but I would find it helpful if you could just set out on paper the range of options that you are saying, because you've included injunctions and the like alongside possible supervision orders and care orders and so on.
Yes, so
it would be helpful if you could just prepare that list, if that's...
We will do.
Paragraph 90 seems to have some of it.
My Lord, I was about to take you to that. Absolutely. It's EF 118, paragraph 90 of our written submissions.
With 92, perhaps.
Yes. But of course, what we were the focus there was the supervision order. But of course, a range of options must include a care order at home. My Lord, my Lady will do that.
Can you help me about the practicality of the supervision order? If the judge's assessment of the risks is right, if mothers simply can't be relied upon to protect the children against, particularly because she's got a blind spot about him. She's still managing his finances. She's got power of attorney. She's clearly very bound up with his needs. The judge worried not only about the single incident where A interfered with E, but also he worried very much, didn't he, about the antecedent, the earlier visit to Butlins. Now, what in practice do you say can be done by way of a supervision order to reduce the opportunities for mothers simply to find it impossible to protect her daughters?
My Lord, we have to stand back and look at the other evidence in respect to those matters. There had been, since March 2020, no evidence that the mother or A had breached the injunction. And there was evidence that the Lundra did deal with about the mother's compliance with orders. There wasn't any suggestion from the local authority. And of course, there would have needed to be, if a supervision order was properly considered, and my Lord's question carefully considered by His Honour, regard to the status at the time that A was allowed into the home, and whether or not there were sufficiently clear boundaries and guidelines, because some parents need those boundaries and guidance. If they're put in place by the authorities, they comply with them. That's different to parents who just disregard the rules and the boundaries. I don't know if my lord has frozen. Yes, he has. Yes. Yes. Do we continue?
No, we pause until we get
Yes.
him back.
Thank you. Whether are these in the papers? Okay. That's quite, yeah.
Ms. Markham, I think what we'll do is we'll actually adjourn for 5 minutes for two reasons. One, to get Lord Hughes back with us, and two, to see if our IT people can improve the sound. I don't know about you, but on the bench, some of us at least are struggling to pick up clearly what Lord Hughes is saying. We're getting the gist, but not necessarily every word.
Thank you.
I doubt if that's a serious problem.
We've got to go.
Been and gone. What we will do is we'll adjourn for 5 minutes to see if we can cure both problems.
Thank you.
Thank you very much. I'm sorry for the interruption, Ms. Markham. I hope the problem will now be solved.
Thank you. I was addressing my lords and my lady on the question of the concern of what had happened in 2017 and the breaches, and why things might be different under either a supervision order with clear boundaries and expectations or a care order. And I wanted just to take my lord and my lady back to the evidence, which is, and I'm just going to hopefully find you the references in respect of Gracie, but of course the evidence before His Honour at this final hearing was that under an interim care order throughout the entirety of F's life, apologies for using her name, she had remained at home with no concerns. And of course, the local authority conceded that the parents were doing a great job with her. There had been no concerns.
Yes, sir.
There had been no issues about breaches of written agreements. Of course, what happened in that November 2019 happened in almost a gap in time, when there had been perhaps even some mixed messages. There was the agreement with the local authority that A could go home and be in the household.
But for a limited, for a tea and
No,
something like that.
but I'm talking about the principles and the stark difference between what happens when we say to a family, it is a no and here's an order and it's injunction.
Yeah.
There's no evidence that this family breached any of those clear boundaries and guidelines. And that was something that His Honour should have had regard to when you're looking at this draconian last step. I'm also told by my learned junior, Miss Makepeace-Grieve, that having finished as they did the evidence late on the 5th day, that overnight, and apologies, we're going to see if we can get this document again helpful for my Lord's request about the alternatives. An alternative care plan was suggested to His Honour that put in place all of the safeguards. And again, the reason I didn't know about that is because working through the judgment, there's no reference to it. So there's no reference to I've had regard to an alternative way of managing the family, working with the family to keep them together. But for these reasons, I don't consider that that meets the protective needs balanced against all of the other risks for this family.
Well, sorry, an alternative care plan was put forward by the local authority?
No, by the mother, on behalf of the mother.
And what was that? What was the substance of it?
It is the detail of paragraph 90 plus some other submissions, I'm told.
So
Yes,
it was,
and it was put under either care or supervision order.
that was my next
Yes.
question. So it was
Yes.
either a care order at home
Yes,
or a supervision order?
indeed, yes.
Right.
Can I also be clear? Are you telling us that there's no evidence that there's been any breach of a non-molestation order stroke injunction?
Yes, I am.
What, therefore, did you say there was a breach of? When you said there was a breach of a written agreement, I mean, what exactly has the breach comprised?
No, there hasn't been. Since the incident in November 2019,
Yeah.
there has been no breach of anything asked of this mother and the second appellant.
What was the incident in 2009 a breach of?
2019.
2019.
There was a tacit agreement that A could go into the household to spend time with the mother and the siblings, and that he should only spend short periods of time there. A is a vulnerable young man. He had been targeted in his accommodation in quite a significant and severe way, and came to the home of mother and the second appellant, and they allowed him to stay. There was no formal written agreement in place at that time because the local authority had determined that the children would no longer be children in need and had withdrawn. And so I am not standing here to say that that was anything other than wrong. But if my lord and my lady are asking me if it was a breach of anything in writing, it was not. And certainly since the case came back before Her Honour Judge Mellenby, the injunction is in place, and before that point in time, there had been no breaches. And of course, there is, and my lord and my lady would say, some confused messages being given across the history, because we see, for example, in the report of the previous expert in 2018, Timberlake, that there was a discussion about how A might actually be rehabilitated back into the family. But what this judge was looking at the point in time he was making the final orders was what safeguards could be put in place to mitigate the risk. And it was important, and I'd go further than that, imperative that in his reasoning, the learned judge looked at what safeguards were in place, had they worked, what other safeguards could work, because of the identified risks to the children of being removed. It's that balance. And we say in this case, the learned judge simply didn't do that. He had a range of options. So I'm bringing it back to the core point, G. He had a range of options open to him that he ought to have considered in respect of each of the individual children's with regard to each of their individual needs. And my learned judge wants me just to remind my lords and my lady that, of course, there were no findings of neglect, nor were there any findings, nor was the learned judge asked to make any findings that the mother and second appellant couldn't manage the risks from F2. So even though my lord raised the 2017 issue, that wasn't a risk factor. So the risk factor, the risk came solely from one direction, and that's from A. And that's important because when you read a whole history, it's important that the distillation of risk is clear, and I would say it was, but it's not about the risk from F2, it's not about the risk of neglect. And I'm just going to check that in my notes that I haven't missed any significant factor, and I'm trying not to rehearse everything you've got in writing because you have that in writing, nor indeed go over that which I have probably already gone over once or twice on behalf of my client. I think it's where, perhaps finishing, if I may, with Lord Justice Jackson says about, in paragraph 57 of the Court of Appeal judgment, it's at 248, EF 248, or 249, I think, electronic bundle. Lord Jackson said that in making every allowance for the fact it was an extempore judgment, he was driven to accept the submission that it does not contain an assessment of the welfare advantages and disadvantages of the rival plans for the children. The judge stated a number of the relevant factors, so he clearly had them in mind, but it's not possible to see how he balanced them out. Instead, there's a stated conclusion that the home is unsafe, which faces the difficulties I've identified above, and prioritises the risk from A, in particular, above all the other factors, without attempting to synthesise those factors with others. And we adopt that, and we say that's at the heart of this appeal.
May I ask this? The judge then goes on to consider, as a second factor, the position of F.
Yes.
And the judge clearly weighs that in the balance as well, that assessment in the balance. Does the position of F stand on its own, as well as a matter to be taken into account?
Well,
how do the two relate together? In other words, if the judge hadn't already come to the conclusion that he's already come to before he came to F, could the position of F actually determine the matter as far as the other children were concerned?
no, I would say the matter of F couldn't. All of the evidence around F and all of the information about how F is being cared for, compliance with written agreements, the interim care order, should have informed and assisted His Honour. But it wouldn't necessarily inform the outcome for the older children, because they each have their own individual needs that should have been considered within the welfare checklist. The difficulty is, which is a difficulty that Lord Justice Jackson has identified, is that having ruled out the mother and the second appellant as carers for all the older children, he's done so for F without properly considering her as an individual.
Yes.
And in particular not considering the checklist for adoption, which is slightly different from the welfare checklist.
Yes.
And that is another significant difficulty in the approach that His Honour Judgment Fee took, because the case referred to in North Yorkshire is a case that can be used in care proceedings at certain stages to rule parents out, but you do so following a proper checklist, and that's set out in North Yorkshire. That wasn't undertaken in this case. But the consequences of the decision, the local authority argue now that, of course, these parents should be treated as having been ruled out to care for F because of this judgment. But of course, we would say that that can't possibly be right. The door must be kept open. And I think that's why Lord Jackson was slightly troubled, and we say rightly so, about the approach being taken to Gracie, to the little one in this case. And of course, he perhaps fell into error because he forgot, the learning judge forgot, that each child needs to be looked at individually.
But as far as Lord Justice Peter Jackson's reasoning is concerned, that's an independent factor. His decision stands irrespective of what he says at 58 to 60.
Yes. Yes, indeed. Had we not had the break, I would be at my time. It seems to me that unless there are some questions at this point in time, I've probably addressed all of the core principles and arguments. I probably repeated them, and apologies for that. I know I have some time to respond at the end. So unless my lords or my ladies have any questions at the moment, my lord does.
Lord Hughes.
Thank you, this, Miss Markham. I just want to pick up the submission that the only risk that the judge was concerned about was the risk from A. Would you have a look when you've got time, please? The judgment 108 to 111 and again 168. By all means, come back later on it. I don't want you to try and do it on your feet.
Grateful.
But it occurs to me that it may be, in fairness to the judge, that he was actually identifying a rather more general risk in mothers' understanding of the need to protect from external dangers, not confined to A.
Yes. No, we will come back to that. I know that Melanie Junior probably wants to have something to say to me about that. Thank you, my lord. Thank you.
Yes.
My lord and my lady know that I represent the man who has been described as F3 in this case, and as has been touched on a moment ago, F3, of course, is not the biological father of C, D and E. He's their stepfather, and as such, their psychological parent. He is the father of the youngest child of the full group, child F, who has just been referred to. And again, as was apparent from the comments a moment ago, child F was the subject of the care proceedings, but not the subject of the final care orders, which were made in relation to C, D and E. But as is obvious, first of all, from Lord Justice Jackson's judgment, and secondly, from Ms Markham's comments a moment ago, the first instance judgment, if it stands after this appeal, impacts in the most significant way on child F, and on any prospect of F3 caring for her, or in fact preventing her from being adopted. And of course, implications of an order such as that are the most far-reaching possible. Also, by way of introduction, it's fortunate for me to follow Miss Markham, Queen's Counsel. She set out a case with which we very largely agree. She's dealt with the difficult questions from Lady and my Lords, which might otherwise have come my way. We entirely agree with and adopt her submissions, and I hope that ours can be the shorter for that reason. We begin our written case, or at least the substance of it, saying this: the judgment of the majority of the Court of Appeal, if it stands, will act significantly to reduce the protection afforded to the most vulnerable in society, facing the most significant intervention in their lives sanctioned by law, in a context where the system is stretched beyond capacity by the numbers of children becoming looked after, with the consequent reduction in the funding available to assist in supporting children to remain in their families. And though, of course, this court and we are dealing today with 3 children and possibly a 4th, we stand by that somewhat bold analysis for these fundamental reasons. Number one, we say that the first instance judgment in question does not engage to any meaningful degree with the crucial question of proportionality. Number two, the decision of this court in 2013 in Re B has subsequently been explained for the benefit of family practitioners and first instance family judges in an important and a well-known series of judgments, largely penned by, can I call them, the children law specialists in the Court of Appeal, judiciary, one of whom, of course, then came onto the panel of this court. But thirdly, the decision of the majority in the Court of Appeal in this particular case, if it stands, would reset the bar and reset it much lower in relation both to the requisite quality of scrutiny at first instance and the requisite degree of scrutiny on appeal in relation to the question of proportionality in children cases. And that being said, of course, in the context of there being a positive duty to justify a state's interference with a subject's right to respect for family and private life. In relation to the question put to Mr Markham by my Lord Burrows at the beginning of her submissions, we agree that questions A and B of ground 1 as set for us were dealt with by the learned judge at first instance. It's questions C and D which weren't. But we say this, those two questions, C and D, are the crucial questions, because they are the questions which elevate a judgment, if properly answered, from one which is linear to one which truly engages with issues of proportionality. A and B require the identification of harm, or the likelihood of harm, and the consequences of such harm arising. And of course, the classic linear judgment, so criticised by this court and then subsequently by so many judgments in the Court of Appeal, stopped pretty much after B. Question, is there likelihood of harm? Yes. Question, what are the consequences? Pretty bad. Answer, therefore, none of the non-draconian options stand. We have to move to one which protects against that, which by definition has to be placement outside the family, which by definition for a very young child almost certainly will be an adoptive placement. And for all the reasons given in Read B and subsequently, that isn't the apposite test. So we say it's those two questions which are crucial. But also then, and again, perhaps engaging with a question from the bench, from his question, certainly a multiplicity of lists and tests will not be helpful for hard-pressed first instance judges, and still less for hard-pressed courts of appeal trying to work out whether the right questions were asked and answered. But there are two different exercises which are required, and there must certainly be two different lists, because the welfare checklist is hugely important. Of course, it's useful. It is the essential list of ingredients in any particular case. But answering, faithfully dealing with each of the questions on the welfare checklist doesn't of itself indicate how they're to be weighed or what the answer is. Now, that doesn't matter if the question before the first instance tribunal is one of pure discretion. But it matters if, as is clear from the case law in relation either to threshold or to disposal in a case which engages Article 8, when the question is a value judgment, as with proportionality. And whilst it may well be that the same factors would be looked at, evaluated and weighed, whether through the 8 factors in the welfare checklist or in a proportionality checklist, the difference is that a proper proportionality approach tells the court how to deal with the various factors. The type of harm, the characteristics of the child, the ability of the parents, etc., all need to be weighed. But if the final question is, what is the nature of the harm from which we're seeking to protect these children, and does the intervention proposed is it necessitated by the degree of harm, then the questions have to be asked in a different way. So whether it's the list of Re-F or a slightly differently constituted list, it's properly applying the judicial mind to proportionality, which gives the recipe to the ingredients otherwise contained in the welfare checklist. Now, The local authorities say in this case that our criticism is effectively one of form and not substance. The straw man is erected, we're then told it is an inapt criticism. But may I be clear, our case is that we squarely criticise the first instance judgment in relation to its substance, or its lack of substance, in relation to the crucial questions. I hope to meet face on my Lord Hughes's questions in relation to the extemporary nature of the judgment, and the fact that, given its extemporary nature, the order in which various matters are put may not be optimal. The local authority rely on the DAM case. It's not a good comparison, we say. It was a highly unusual case on its facts, but also highly unusual because we don't see the first instance judgment. It's clear from Lord Justice Peter Jackson's final paragraph, if nowhere else, that it was a very unusually structured judgment. The final paragraph of that case, after having dismissed the appeal, it's at page EF 1738, said this: however, I'm also in no doubt that permission to appeal was rightly granted had the judgment proceeded simply and methodically through the stages of the decision-making process. This might have been avoided. It should not be necessary for an appeal court to undertake a laborious explanatory exercise of the kind contained in this judgment. And in the judgment which preceded that final paragraph, Lord Justice Jackson was able, just about, to pick out the various components from the judgment which enabled the Court of Appeal, with that criticism, to say the judge undertook the correct procedure. The current case, we say, is rather more akin to Re G, which my lords and my lady find at page 1411. Paragraph 57 of which has Lord Justice McFarland saying, in my view, despite the impressive factual analysis that takes up the main body of the judgment, the district judge's conclusion in the present case fails to indicate that the judge undertook an holistic evaluation of the welfare options for Jay's future in the manner that I've described. Mr. Sharp's submission that, quote, when we get to the bit that matters, the district judge needed to carry out a balancing exercise to identify the risks of separating J from M in contrast to the risks of returning home, close quote, is entirely well made. We say that even if the collective judicial minds present today look carefully at the judgment to try to extract from this paragraph or that paragraph the bits which might enable a judge to come to a lawful conclusion in relation to proportionality, that simply isn't possible. And even if it were just about possible, it wouldn't be permissible given the onus on the first instance judge actually to weigh X, or to evaluate X, evaluate Y, and then faithfully to compare the two of them. Of course, having made a number of broader points, it comes down, as my lady indicated, to a textual analysis. In many ways, appeals always do, no matter how grand the opening remarks are in relation to them. But we say a number of important factors and considerations are simply absent from this judgment, and that their absence mandates this court to say the first instance procedure was not correctly undertaken. There is no methodical consideration of possible mitigating factors. That's question C. So question A, is there a risk? Of course there is. Question B, how bad would it be if it happened? Well, terrible. Question C, what can we do before intervening? Necessary question for obvious reasons, but of course in the context of European jurisprudence and the mandate on the state to seek to rebuild a family or maintain a family rather than take it apart, a crucial question. It's simply not there. How extraordinary, we would say, that in answer to a question from a justice where, Ms Markham, is the non-molestation order mentioned, the answer is nowhere. It demonstrates that, in fact, because there was no systematic analysis of how to mitigate risk and the actual value of each of the two options, important matters were simply not considered. The impact of the supervision order wasn't mentioned. Input to be provided by the school or others, the other professional people in contact with the children, not mentioned. As pointed out in the exchange between my lady and Miss Markham in relation to possible orders, it's not, if it was simply, if section 13G was simply dealt with in isolation, it wasn't at all, but if it had been, a judge might say the range of options open to me are care order, supervision order, no order, whatever else, child arrangements order, special guardianship order. If that exercise is properly undertaken in the context of proportionality, it has to be how can various different orders impact on the possible final decision for the child, should she be in X place or should she be in Y place. And no mention at all of, first of all, supervision order, but secondly, the prospect of the local authority sharing parental responsibility with all the extra safeguards that would entail. I can't say to the court that that would necessarily do the trick, because I'm not the first instance judge, but the point is neither did the judge say that. So it's another aspect in relation to which this court doesn't know the answer. This court does know, of course, that post the Portneath-Talbot case, a judge can analyse risk and say to an authority, there is to be a care order and there is to be placement at home, and the authority has to work with the risk as assessed by the judge. So it isn't a fanciful option in this case, although it's one which simply isn't mentioned. The focus on the judgment, in the judgment, is almost exclusively on the potential harm that the parents, by which I mean principally the mother and F3, might cause to the children by the possible exposure to A, or as Lord Hughes indicates, possibly F2 or AN other. Because the focus is on that, and because, as is seen from the judgment, the consequence in terms of reasoning from that is simply the children cannot be safe. That is why it seems there's no proper thought given to the other factors. The case law that follows Re B, to which I referred, which is well known, cited in all of our documents, gave rise to the possibly slightly jargonistic expression, global holistic evaluation. And once that expression took on rather more currency than perhaps was intended, Lord Justice Macfarlane said in another judgment, all I meant to say by that is the good old-fashioned welfare exercise.
I mean, I think in relation to that, it's apt you mentioned it. It doesn't have to be a counsel of perfection. That is the point. It also shouldn't be formulaic. And the point that I come back to is this judge took a lot of care, having heard witnesses, expert evidence, over 6 days to produce a judgment. He has referred to some of the options. He has referred to the need for parental responsibility, for instance, which arguably is hard to resist given the assessment about capability. So he perhaps hasn't put it in the right order, but that's not fatal. And is the point more to do with the obligation under Article 8 to explain necessity, in fact, or an intervention?
Lady, certainly that is the flaw that we identify, but in fact, picking up on my lady's description there, he does identify some of the factors. Yeah. Yes, he does, but not all of them. And the factors aren't identified in a way which allows this court or the court below to say, even if it's done in an eccentric way or done in a hurried way because it's at the end of a long trial, we're satisfied that the court has done, and this is the absolute central dictum from all of the cases following Re B that we refer to, the court has to say what are the realistic options, and internally, what are the pros and cons of each of them. It doesn't matter how that happens, if it's in a spreadsheet or a checklist, or if each factor is taken side by side, or however it's done, but it has to be done. And when it's not done, it becomes impossible to undertake the final proportionality exercise, which is, I've done that now, I know what the risks are for both, what the pros are for both, I can weigh which is better for the children, and by the way, is my final analysis proportionate in the true sense? That simply can't be done. Because as I hope I'll set out, even though, as Amanda says, some of the factors are referred to, they're just not all. And even when referred to, very often there's no analysis, in fact. So, for example, Milady took Miss Markham, I think, to paragraphs 143, 4 and 5.
142 to 145 arguably is the operative part for me, where there's mention of options, there's mention of supervision order, there's mention of care order. There's no mention, I know, of injunction or non-molestation, but there is a reflection on the attributes of options as well in 143 and 144.
Well, no, yes, except that all the judge in fact is doing there is setting out what the submissions made on behalf of the parents are, which is a perfectly valid exercise. One would expect to see the counter submissions set out, but what's crucial and what's missing is an evaluation. Right. I disagree with the parents because, in this case, I'm driven to the conclusion that the authority is right because this risk is too great. So we see there the proposals of the parties are F3 and M say X. If they can't, they wonder whether, next paragraph, they say that. And then the only actual analysis, if that's what it is at 146. I accept and acknowledge they love their children dearly. It doesn't in fact engage with the arguments cited at 143, 4 and 5, and then sets out the local authority case, classically linear, we would say. The authority is simple in its assertion, they failed to protect the children before. Then an expert's view is cited, another father, the guardian. So we have the parents, or the parties' positions set out up to 150, with no analysis, in fact, of those positions. Perhaps it was too early to do that, because the next part of the judgment, one could put a heading above 151, welfare checklist, because then, and this is the point made that Lord Justice Jackson did this for us, we fall into the welfare checklist. But again, in the most rudimentary way possible, we say. But again, all factors are important in a welfare checklist. In a case such as this, the two crunching factors that compete with each other are risk of harm and change of circumstances. And change of circumstances, of course, is the crucial part of the parent's case. And all one has here, again, 156 and 157, the parents' views are set out. The likely effect, the paragraph 156, the contention of the parents' lawyers is that, ... Next paragraph, the likely effect the parents say is ... And then the closest we get to analysis again is paragraph 158, which doesn't begin to do justice to the issues involved. There's always a risk in foster placements of a breakdown of the foster placement if a child's so disruptive they can't settle. Of course, the authority plan is they seek to support the foster placements. One needs to seek to avoid the need for children, as far as possible, to have that domino effect of one placement after another collapsing. And then we move on straight away. That's it. That's change of circumstances, analysis dealt with. Paragraph 159, age, sex, background, we would say, as rudimentary as it can be when you have three children of different ages with such different characteristics. Harm dealt with there in two short paragraphs. But then the consequence of the harm is the linear analysis, which one has at 163, 164, and 165. The parents aren't capable of providing for the safe needs of C, D, E, or F. And that linear conclusion made in terms there which suggest, and I take the point about the order of in which a judgment is put together, seems to be the end of any active thought being given to that particular question.
Well, to be fair to the judge, I think he clearly got in mind not just the evidence of Dr. Friedman, but also the social workers and the children's guardian.
Yes.
So one might say there was a wall of evidence supporting the judge's approach.
Well, yes, but we're quite unable. Well, supporting what? Supporting the conclusion that there's an ongoing risk of harm, certainly. We couldn't begin to gainsay that.
Yes.
Supporting the conclusion that that harm couldn't be mitigated, we don't agree. And supporting the conclusion that having assessed that risk of harm and the risk of harm certainly corollary to a placement in foster care, the harm in foster care is justified by avoiding the harm by staying at home, which is the final question, which is missing at each part of what we say is a string of linear approaches to this. The particular deficit inherent in the absence of any consideration of the risk of foster care is every time we see any reference to foster care, we have only the strangest, most starkly rudimentary assessments of that. For example, back at 172, so paragraph 172, the judge returns to foster care, returns to the need or the potential danger of breakdown of a placement. Of course, that's an important consideration. And then the most that we read actually about the judge making an assessment of the impact on these three children of foster care is parenthetically in the middle of that paragraph, in circumstances where they don't know they're going to separate foster placements, and in circumstances where they're likely to create some degree of uproar and commotion through the outleashing of emotion from each of them towards their foster carers, there's a risk of breakdown. For sure there's a risk of breakdown, but where on earth, where in this judgment do we read that any proper analysis has been given or effect taken of the certain consequence of foster care, which would be the most profound distress for each of the children?
Is that not self-evident in a case like this?
Well,
in the sense of you have, as you've already said, 3 children who've never been out of parental care. I mean, is that really a valid criticism that it's not written in black and white? The judge has taken all of this arguably into account in terms of the issue with foster care. He talks about it being separate placements, the disruption. I mean, is that really core to this? That he hasn't looked at the effect on the children?
With respect, it's crucial to this. Right. Because there are 3 different children, and it says it's self-evident that...
Well, sorry, my point is it's self-evident, obviously.
Yes, it is self-evident, but what isn't either self-evident or even inferentially evident is that the judge actually weighed the harm of each of the 2 options, assessed the harm of each of the 2 options, and then weighed them one against the other. And that is what proportionality means, almost no more and no less than that. And all we have instead is, these bad things have happened, the parents have behaved badly, there is a risk of future harm, the children can't be safe, that's the end of it. That in fact should be part of a holistic evaluation of option A, and should involve rather more than that. However, the positives of being with their parents are staying with siblings, settling in school, whatever else there is. Before then, the same exercise being undertaken in relation to foster care. So, advantage of foster care, it keeps the children safe from the risk identified as emanating from the parents. But disadvantages to foster care, absolutely huge. As Maddie says, self-evidently so, but not present here, but different for each of the children. We know how we set out in our document how different each of them are, their characteristics are. And there's nothing at all to suggest in this that was actually factored into what we say is almost a paradigm example of the linear analysis. Lord Justice Jackson says in terms, in his judgment, this was all the more important when the case for permanent removal was not clear-cut. And whilst we accept that each of the professionals said there's a risk, and we accept that each of them said the children should be removed. In fact, the judge's job is to weigh what they say in the balance when undertaking the job mandated, and with respect to the judge, repeated a dozen or so times in the Court of Appeal since Re B, which is not good enough just to say what's the harm of staying where you are. You've got to look closely, properly, holistically at both options. You've got to weigh each of the options, and only then are you in a position to say this is a proportionate interference with these children's lives. We say, first of all, with this particular judgment, that is absolutely, obviously, completely lacking. It is the classic linear judgment. And the bolder point with which I started is this. The consequence of this judgment in the Court of Appeal standing is that all of the good work, as it were, that's gone in over the last how many years since, or 8 years since Re B, to making sure that in difficult cases with difficult competing rights, judges undertake a sufficiently robust process will be undone. Because this, allowing for the time of the afternoon, allowing for the length of the hearing, allowing for the extemporary nature of it, this doesn't begin to engage, in fact, with what it says is engaging with, which is a holistic evaluation and then a comparison. Turning to a legal matter which might impact on this, we disagree with the local authority's assessment of Re G and what it says. If my Lords, may you kind of have to turn to page 173.
173.
One sees the process versus outcome heading above paragraph 42. And then a citation from paragraph 28 of Re B, which ends in this way. The determination in the present case, removal of the child to public care with limited ongoing parental contact for an indefinite period which may run for 10 years, being the remainder of his childhood, whilst being of a lower order of intervention, must, in my view, fall to be considered in like manner with the difference in the level of intervention, full stop, end quote. And then the dictum which it said flows from that is, therefore, the degree of interference with Article 8 is reflected in the intensity of scrutiny applied through the proportionality assessment. Now, we don't agree with that, and if one turns via the hyperlink to the actual quotation from Re G, one sees the intervention, whilst being of a lower order of intervention, must, in my view, fall to be considered in a like manner with the difference in the level of intervention, term page, being reflected in the application of the yardstick of proportionality, and thus the evaluation of whether the proposed order and care plan are necessary. So we do not accept that a lower degree of scrutiny is necessary. All I think that's being said there is that the yardstick, I was going to say that the length of the yardstick will vary. Of course, that's an impossibility. But the degree of intervention which is inherent in any particular proposal becomes the yardstick against which the harm is to be assessed. And the point we say, Lord Justice McFarlane is making here, is the opposite almost of what is being said. That although this isn't quite an adoption, this is an extreme case in terms of the consequences of the intervention, the degree of interference with each of the three children, and with the mother, and perhaps to a lesser extent to F3. And because of that, the same exercise needs to be gone through, albeit that the nothing else will do maxim probably doesn't apply because it's not adoption. And we say this is at the extreme end of care orders, really for two reasons, and in relation to both ends of the sibling spectrum. E was 8 at the time of judgment. So what is contemplated is 10 years for her in foster care, with very limited contact every 2 months, with no work to rehabilitate, despite the fact that that is clearly what European jurisprudence tells us ought to be the aim of any non-adoption removal from familial care. And in the context, and this we say is another huge deficit in the judgment, in the context of there being an almost complete cessation in sibling contact. These girls have lived together for all this period, and they're going to separate foster placements on these care plans with very, very infrequent contact with each other. And in the context, it's agreed that that will be devastating to each of them. So that's E. For C, she was 13 at the time, so a less lengthy period in foster care, but perhaps a huger impact. A child, if not capacitous, and I wasn't there at first instance, so I can't say, certainly now on the very cusp of being capacitous, with very strong opinions about her future, being separated from her parents and her siblings. And of course, if we're right about the further implications of this judgment beyond the children who are actually before this court, in relation to child F, the most significant interference possible. And so we say, rather than, as the authority says, well, if it's not adoption, a lower level of scrutiny is needed, we say, no, in fact, this is as close as you get to adoption. For one of the children, it virtually is going to be adoption. And in those circumstances, whatever latitude is properly allowed to judges in the difficult circumstances in which Judge McPhee found himself, the court has to be able to say, however it's been done, we are satisfied that each of the options has been properly considered, each of the factors which must be part of that consideration has been considered, and then having done that, the two have been compared side by side. And anything less than that, anything which comes closer to these girls are at risk of harm with their parents, therefore we keep them safe in foster care, is an illegitimate judicial approach, redolent of the perhaps the prevailing circumstances before EB, and one, if it's allowed to stand, which sets back the human rights progress made by and in the wake of EB very significantly. Lord Mayor, I think I've uncharacteristically taken less time than I was given, which I'm happy to fill in answering any difficult questions that weren't asked of Ms Markham.
There is no obligation to fill in time, but if there are any questions, they will be asked. Lord Hughes.
Mr. Tyler, I probably should have asked Ms Markham, but she's coming back later and can deal with it then. Supposing the court were to be with you, you want to say what ought to happen?
Well, yes, I have to say that we in this team have struggled slightly with that because practicalities and the fact that there are 3 children before the court and the fact that the Guardian has formed a clear view that the dangers of further delay for the children are greater than the dangers of living with their parents, which perhaps tells the court something in itself. We would like to say to the court that the appropriate course is that this court looks at everything, looks at that new evidence effectively via the Guardian, and says supervision orders are the appropriate course. There are various mitigations that can be put in place, and the fact that we're as far further on as we are, in the absence of there being any breaches, demonstrates at least that in the gaze of the potential for problems, these parents can make good on what they say, and so supervision orders ought to be replaced or substituted. We acknowledge, though, that the more logical legal consequence of what we say is this. We say this court can't step in and say, Judge McPhee made the right decision, albeit there are a couple of missing links. We say there are so many missing links, so many fatal deficits, both individually, but certainly when taken collectively, that the case has to be remitted to be reheard by a judge who, as well as hearing the original evidence, making the primary findings if necessary, can then undertake the exercise that thus far has been absent. So, whilst we would love to be in a position to say certainly the court can substitute, for pragmatic reasons it could do, and in the knowledge that the guardian's concerns are significantly motivated by what I understand to be, I don't want to give evidence, but I understand to be probably significant and worrying and increasing distress on the part of the subject children. We also recognise that the court may be driven, if it accepts our analysis of the judgment being as flawed as it is, in as many ways as it is, would have to say a judge needs to hear the evidence. We don't go behind Piglovska, and we agree that in many ways the Piglovska advantages the judge had must have helped him significantly. But what we say is, having undertaken that exercise, a bit like in the Reg case I took my Lord to my Lady to a moment ago, he simply didn't use the core facts as he saw them and found them to undertake the difficult exercise which he should have done, and that is why the judgment has to fall.
Sorry, Lord Hughes.
That's persuading us, if you're right, that the judge didn't ask the right question. But supposing we're with you on that, how on earth is any appellate court, let alone one as remote as this from the front line, supposed to assess the potential effectiveness of alternative orders without seeing the people concerned and establishing what Lord Wilson, I think, called the bench to witness box relationship, which is so critical to a first instance judge?
Well,
how do you do it?
Well, that's why, rather more in hope than expectation, I started off saying we would love it if the court could. But then I said, however, if we're right, the legal analysis probably is.
Now, if I mean, these are all hypotheticals at the moment, but if an appellate court inevitably struggles to achieve that, is it an option, despite the difficulties that the judge would have, to return it to him? He's a very experienced family judge, and if you're right, the judgment will explain exactly what issues need to be confronted, and then he can answer them on the basis of his assessment of the people.
Well, if Mr. Woodward-Carlton were right, and the deficits are formal rather than substantive, I could possibly agree. But they're not. We say that the deficits are substantive, both in terms of significant absences from the judgment, but also, because of that, inapt conclusions reached. And if we're right that there's a linearity to more than one passage in the judgment, which concludes, effectively says, the girls are at risk, therefore they can't be kept safe in their parents' home, therefore their parents can't live with them, then we would say it would be wholly wrong for the case to be returned to Judge McPhee, who would have to perform the sort of mental gymnastics that even an experienced judge couldn't perform. And even if it were theoretically possible for a judge not just to re-input those parts he didn't input to start with, but also to step back from firm conclusions reached, then it would certainly have the appearance of significant injustice to those who've already been told by him, you can't look after your children, and probably not the last one either, if it goes back to that judge. So it might be, in fact, counterintuitively quicker and cleaner if there's a fresh pair of judicial eyes involved, and not least because we hear that the Guardian's stance now is if there is to be significant delay in concluding matters, then I would rather the girls stay where they are under supervision order than that they're removed, as was my original recommendation.
Is there a case ongoing for this family in relation to the youngest child?
yes.
Is that before Judge McPhee?
Yes.
In April, I think.
Yes.
Is that right?
Yes.
It's listed, I think, for 3 or 4 days.
Indeed.
That's in front of Judge McPhee,
Yes.
is it?
Of course, F never left the supervision, effectively, the judicial oversight of,
No.
Judge McPhee, because she was part of the full care proceedings.
Yeah. And really, where you are, if the court is attracted by your arguments, it does come down, it seems to me, to the nuts and bolts, as it were, of alternative arrangements under a care plan or conditions to an alternative under a supervision order or the other orders that could be attached. So that is something I think you've agreed with Lord Hughes that a court needs to look at in a certain way.
Yes. So it comes down on the one side to the nuts and bolts analysis.
Yeah.
But on the other side, they worked out how significant a protective structure those various nuts and bolts could provide.
Yeah.
And the nuts and bolts include the different sorts of order. Then, does that provide a solution which is the least worst option for the girls? And often the previous president would tell us that it's the least worst option, sadly, in care proceedings, which is all that is sought by the judge. Whether the least worst option would be to stay there with those nuts and bolts in place than to suffer the certain harm, which would be secondary to their removal into separate foster placements, severance, effectively, of parental relationships, and severance of any semblance of normal sibling relationships.
Okay. Thank you.
Thank you very much.
Well, thank you.
Yes, Mr. Carlton.
On behalf of the local authority, my lady, my lords, there has been a significant narrowing when it comes to, I think, the legal questions in this case, and I won't rehearse, but perhaps I can address two matters briefly that are alluded to and, in fact, set out in our written case. The first of which starts at 166, that's internal page 8 of our document, and it relates to the issue of the holistic analysis and what's required for a proper assessment. You've heard a significant amount about this. Over the page on 167, for ease, rather than use the hyperlinks, I've endeavoured to set out the paragraphs to which I refer. But at paragraph 49 of that case, the case of Re G, which coined this phrase and as has been alluded to, perhaps has become more used than intended, I would simply draw the court's attention to what a linear analysis, as criticised there, actually involves, and because that, in my submission, will set up our evaluation of this, which is this isn't a linear analysis in this case. What the Lord Justice McFarlane was warning against was going in order, sequentially through the options, and having ruled out the first, possibly second or third if they exist, getting to the final option, and then accepting that without significant scrutiny. And with respect, that's the crucial thing. It's that getting to that final option, it would be wrong simply to accept it because it's the last option standing. That, I will say in due course, is clearly not what happened here. We did work through the options, the judge worked through the options, but subjected the final option, the option of removal to foster care, to scrutiny, looked at its internal deficits, you've been referred to some of those paragraphs already, and formed a view looking at all the options in respect of their merits and demerits. The criticism, therefore, of linear analysis can only apply if the last standing option was not considered fully, pros and cons. The other factor to be taken, and again, I don't ask you to turn to a bit, it's at 1408, it's this case, Re G, is that it's quite clear that when a judge is evaluating the options under the welfare checklist, there's going to be an analysis of the options that come under G explicitly considered as one goes along through the checklist. So, for example, looking at the wishes and feelings of children, almost inevitably, especially in this case, with one of the children, the oldest of the three children we're dealing with here, they clearly had strong views about removal. And that can occur, that analysis, that observation and that evaluation can occur under that part of the checklist, and in fact does in Judge McPhee's judgment. And legitimately, there can be allusions and references and evaluation of the various options at different points in the checklist, not just under G. So if anything, there's a non-linear approach adopted to slightly amend that term, because as we look at His Honour Judge McPhee's judgment, at different places in his evaluation of the checklist, he raises the issues of what does this mean for the options before this court, particularly and rightly because we're looking at realistic options, not every possible option. And the realistic options here were stay at home in some form, or have to be removed to foster care. And so they're the two options that are weighed, and repeatedly, and I don't rehearse the paragraphs that you've taken us to, my lady and my lords, but repeatedly there are the pros and cons at different points of the risks at home and what could happen in foster care, both generally and specifically with these children. So they're the 2 points I would invite the court to take from Re G. Firstly, a caution as to what a linear exercise actually is, and secondly, the non-linear nature of an evaluation under the welfare checklist and how that's right. And perhaps interestingly and parenthetically, what the Lord Justice McFarlane says in Re G is not so much concerned with what appears on the paper. It's just to be clear from reading a judgment what the thought process was, what was in the mind of the judge. So it happens before, the concentration in thinking before it's set down in writing. And if that can be gleaned from the judgment, the form isn't so important. And I will come, therefore, back to the form and substance argument, if I may. Unless you wish to ask questions on Re G, I would move to that form and substance argument.
Mr. Carlton-Woodward, may I just intersect momentarily, because you and Mr. Tyler are using the expression linear in rather different senses. For my part, it strikes me that you may be nearer to what Lord Justice McFarlane meant. But what Mr. Tyler is saying, whether you call it linear or something else, is that the one thing the judge hasn't done is to compare, as it were, the options and assess which is the lesser of the two evils. That's the first thing. The second is that he has not at any point attempted an analysis of how the risk, which is clearly there, might be mitigated by alternative means.
Indeed. Well, my
We'll be
lord,
coming to that, no doubt.
if I may come to that, because I'll try and structure it so that I look at the judgment itself in more detail under those two C and D, if we can call them that, the C and D elements of the permission. Yes, I think there is a distinction to be made, my lord, between the way Mr. Tyler uses linear, perhaps. I take us back to the case because the criticism, because it's being described, I understand on behalf of the second appellant, as this is a paradigm non-linear or paradigm linear judgment. So my understanding is that the intention was, on behalf of the second appellants, to be critical of this judgment on the basis of the Re G meaning of linear. There may be alternative reasons to criticise the judgment, which I'll seek to address, but in terms of linear, my understanding is that's the nature of the criticism, certainly as it's partly put, because it's primarily described in terms of this judgment, Re G. Perhaps if I can come back to the mitigation point and the balancing point, my lord, in one moment, if I can simply deal with the point of substance and form, which again has been anticipated by the bench, and I will seek not to be too long. What's said at page 169 of our written case in Re Dam or Re DAM, the 2018 case, is that was such an unusual case, relatively little weight can be attached to the comments made. Well, with respect, those comments that we have set out, those passages on 169 and 170, are primarily or largely comments of general application about the nature of judgments. They're not specifically about the unusual structure of the case at first instance in this case. There is some reference to that, admittedly, in subparagraph 4 on page 170. But broadly, this is saying, as is clear, that there are different forms of judgment, and it's not the form that's important, and that there can be wide variations. And interestingly, looking at, on page 70, those 3 paragraphs, there is a large degree of latitude afforded to judges who, when taking their judgment as a whole, have clearly dealt with and considered and thought about, however they choose to express, which is the nature of judgment. That's what it is, it's a judgment. And it isn't a formulaic approach whereby a set menu is given which is ticked and it's worded in a way which no one therefore can criticise. There are going to be different forms of expression, inevitably. There are going to be different structures of judgment. But it's the overall structure, even if it's not methodical, as it's said here. The interesting case, perhaps, the interesting element of this first instance case, when one looks at the comments about the first instance judgment in Re DAM, it's quite clear that this was a situation where one had to garner components of the proportionality exercise and the welfare exercise from across a huge range of paragraphs. I think Lord Justice Jackson identifies 11 welfare elements that he describes could be understood from the judgment, and they are spread from between paragraph 7 and 75 in the judgment. So that really is a question of trying to pull together the meaning. And yet, in that case, by way of one example, it was possible to do so and to say, yes, everything's there. All the right notes, not necessarily in the right order, but they're there. And so we say that that's important when looking at the context of this particular judgment. And that brings us briefly onto our middle passage, if I can put it like that, the wider application of our case. Because we say, when one looks at the realities of giving judgment in the family division, the pressures on the whole system, which I think everybody acknowledges, are pushing at an open door when it comes to that. But the realities are that giving an extempore judgment after a 6-day fact-finding exercise, late in the afternoon into the early evening, it's not just about the time to prepare that judgment, which is limited, and the marshalling of a huge range of facts in this case. It's also that benefit we all have when we're preparing documents in normal circumstances of reviewing and perhaps saying, actually, this could be better phrased, it could be more methodical, we can move that paragraph to there and it would flow better. That's also absent in any extempore exercise that any judge undertakes, because it's given there and then. And part of the reason it was given at that stage was to avoid the inevitable delay, because we knew the judge was going on to another case. And so any delay in giving the judgment at that point would have meant a delay for the family in hearing and the safety of the children. So those points I raise in the document, forgive me, at 177. And just the caution that in these, forgive me, 182, paragraph 66, the caution we invite this court to take in requiring of lower courts a gold standard when it comes to judgments, which we describe, I hope not unfairly, as unrealistic and potentially unachievable within the constraints of the system as we face it now. In an ideal world, this judgment could have been crafted differently and we simply wouldn't be here. It's arguable, in my submission, that the addition of a few sentences could have meant that this judgment simply wasn't going to be scrutinised by the appellate courts. And would that be a proportionate approach to looking at this judgment and saying, but for one or two sentences, and I know that's not agreed on behalf of the appellants, but from our case, this would be clearly on one side of the law, rather than, as Lord Justice Lewison said, I don't say this is wrong. The core issues then that are in dispute are effectively the factual ones relating to and the dealing with subparagraph C and D of the permission. It's what did the judge have to rely on when it came to mitigating factors, and how did he deal with those things? And related and inevitably overlapping, although we talk about them discreetly, there's an inevitable overlap with the fourth question, D, which is the comparative welfare advantages and disadvantages. We set out our analysis of this from page 190, and it may be of assistance to go from there. As I think Lord Kitchen alluded to, that this judge was presented and the court was presented with a wall of evidence about the nature of the risk, the consequences of those risks, and, in my submission, very clearly, what mitigation might or might not be possible, particularly in relation to this family, to enable the children to remain at home. We know that the judge heard at length, having read a very long report from Dr. Friedman, that set out, and what the judge made of that. In my submission, it's important to bear in mind that whilst we look at the mitigating factors, and we're focusing very much on what happened in 2019 between the oldest child, A, and E, we are, as has been made abundantly clear in this, we are concerned with what happened in 2017 as well, a sexual risk from another direction within this case. That's F2 and the sexual risk he posed. This is the holiday in Butlins. And we're quite clear that this is all against a background of obvious and explored sexual risk that was occurring from the latest that we know of, 2009. When we look at the judgment in the Bund, and I don't ask the court to turn to it, but when we look at the judgment from 2014 of His Honour Judge Wright, it's quite clear that there was sexually inappropriate behaviour in this family. The family were totally aware of it. It was explored. They gave evidence themselves on it. There was expert evidence. So that's the context. And importantly, that this judge had in mind, in my submission, that because Dr. Friedman alluded to it and actually explicitly questioned it, this judge had in mind, and at the forefront of his mind, that this was a family who had said all the right things in 2013 and 2014. This was a mother who was able to persuade the court, and it's set out in the agreed chronology at 80 and 81, for reference. This was a mother who persuaded the court she was alive to and protective in respect of the risk emanating from F2. The sexual risks were fully explored there, but particularly in relation to F2. It was on that basis, partly, that His Honour Judge Wright felt emboldened to say the answer at that stage was a supervision order made in March 2014. Had that supervision order, and it wasn't, it lasted for 12 months, but had it been extended for 3 years, it would have taken us to March 2017. After that, we don't know whether there's a causative effect, there's no evidence or not, but we know that despite what Mother said about her understanding of the risk from F2, at the end of that year, 2017, she went on holiday with her daughter and F2's daughter. And this only came out, this wasn't obvious, it wasn't discussed, it wasn't shared, there was no request for permission. This only came out in conversations with Dr. Friedman. Well, actually, although Lord Justice Jackson said it only came out in the hearing, it came out in the work of Dr. Friedman and then was explored at the hearing. And as Lord Hughes, with respect, rightly observed, this judge, Judge McPhee, was worried about that risk as well. It wasn't simply the risk from A, and that's set out in the judgment. The judge in this case was also very alive to the fact that he observed the reaction of Mother in this case, in the fact-finding hearing, the reaction of Mother to seeing her son on the video link. And he described this, as we say at 186, very clearly identifying the nature of the relationship that persisted between them, in how engaged she was and how upset she was. And that's the vulnerability that we'd seen in November 2019, when the awful abuse took place in the home. So that's the context. The judge had that. He had the evidence of Dr. Friedman. He had the evidence of Dr. Friedman not just about the nature of the risk and the consequences, but also the fact that whichever way Dr. Friedman tried to approach this, it was simply impossible to be confident that mother could be worked with to change her insight and therefore her behaviour. And that primarily stems from a clear and repeatedly expressed view by both mother and F3 that they didn't fully accept the findings of the court. Not just the findings from 2013, but the findings in 2012. 2020. The findings of His Honour Judge McPhee, they simply didn't accept all those. Ultimately, but it was the 2012 findings and the 2014 order they said they didn't understand. Or certainly that's what mother was saying. This, both for Dr. Friedman and for the team manager, Ms. Malik, and for the social worker who'd done so much work with this family, Ms. Ansell, and the guardian who pulled it together from the children's perspective, meant that it was obvious that it simply wasn't possible to do any effective work with the family, particularly mother, who was the decision maker, and that was clear from the judgment. Not F3, it's mother who was calling the shots when it came to decisions, particularly about A. That work couldn't be undertaken. That's primarily and directly a mitigating factor that was removed from this case, because realistically, any option that placed these children or kept these children at home relied on the parents, to put it in a colloquial sense, to get it, to understand what the risk was, to accept there was a risk, and to realise that they had to modify their behaviours, even in extremis, when circumstances pushed them in another direction. For example, when A was found to be in difficulties, they didn't seek agency help, they didn't seek local authority help. He came in and he stayed in. And the timing's interesting. The local authority had been persuaded by the 28th of October 2019 in this case, that this case could close, and they closed the case. That's the 28th of October. Within a week, A was in the home. Within 3 weeks, A had assaulted his younger half-sibling. Forgive me, Lord Hughes.
Those timings are right, of course, but the events which led to A coming to the house could scarcely have been foreseen, could they?
They couldn't be foreseen, my lord. My submission, the import of that is that a crisis occurring in A's life was reacted to by a family who simply hadn't learnt from history. And the risk had persisted from, in my submission, from an awareness, an on notice, if one can put it like that, from 2009, but certainly from the proceedings in 2013 and 2014. And it surfaced when circumstances meant that there should have been a protective reaction. There was no confidence that that would happen. It happened with gaps of years. And with respect, that's important in this case, because the nature of the risk which the court has identified is one that can't simply be said, because things haven't happened for a year, that's fine. Over years, sexually inappropriate behaviour and or sexual abuse or sexually risky behaviour has punctuated the lives of these children.
Can I ask you one thing
Yes.
about the timeline? I had
Yes.
a question in my mind about this. These events of November 2019 are a trigger for the proceedings.
Yes.
But there wasn't an immediate local authority intervention.
No.
So there wasn't an emergency intervention, which you sometimes find. It seemed to me then what happened was there was further discussion of events to a school teacher by one of the children, I think. But so there's a gap then. The date of intervention is what in this case?
Certainly,
November
I think the
19?
proceedings started in March 2020, I believe.
Okay, March 2020.
Yes.
And coincident with that, there is the injunction made, which is roughly about
Yes.
March 2020.
March 2020 by Her Honour Judge Mellenby, I believe, yes.
Okay, but it wasn't a hiatus in November 2019 that caused immediate local authority intervention. There wasn't.
No.
Yeah.
No.
Yeah.
I think there was interaction with the family, but the
Yeah.
nature of that interaction wasn't elevated to proceedings until 2020, until about 3 months later.
Yeah. Yeah.
But you would accept that, as I understand it, there's no evidence of any breach of the non-molestation order or injunction?
No, my lord. My lord,
It
what?
wasn't in place at the time that the incident in November 2019 occurred. I'm not sure whether you accept what your opponents have been saying about what exactly was in place at that time, but as I understand it, you've indicated that the case had been closed.
There was.
Prior to that, I'm not quite sure what that means.
It means that in terms of the status of the family, the status of the children, they could have been referred to either as children in need or children that were protected by the local authority on a register, but they weren't. By that stage, the work with the local authority had ended, as I say, at the end of October 2019. However, there was a clear understanding, again, I think not written, and that's the difficulty, that A should not be in the house other than for having a meal at that point. Now, the wisdom of that remains to be seen, but the fact is, it wasn't, I accept, under any kind of injunction. They weren't under any kind of order. My lord, I endeavour to deal with this, and I'll come back to the actual wording of the judgment, but towards the end of my document at page 202, because this is particularly a specific point made by Lord Justice Jackson and his concern about the judgment of Judge McPhee, which is the mention of and the consideration of a supervision order allied to a non-molestation order and what effect that might have had. And 4 lines from the bottom of the quoted paragraph 54 from the court, so about halfway up the page, at the end of that line, with respect, Lord Justice Jackson rightly uses the word coincided. So there was a coincidence of, in my submission, of supervision order and non-molestation injunction with no reported abuse. In my submission, because of the nature of the risk that kept punctuating this family over many years, it can be said to be no more than a coincidence rather than a causation, if one can put it like that. There isn't, in my submission, any evidence to suggest that the fact of that supervision order and the fact of the non-molestation order was safeguarding the children. It's impossible to say. It may have been. It may have been a persuasive factor. It may have been part of what kept things going. Having said that, many other things changed during that period. The family were represented. The family were in proceedings. There was much more scrutiny again. So there are a range of possible features of that time, one of which was the orders in place, which may or may not have been somehow instrumental in nothing happening.
Yes, but the point you've made about timing illustrates that the children must have been on the child protection register at some stage throughout all of this history.
Yes.
And then subject to a child protection plan.
Yes.
And then taken off when the trust or the local authority closed the case, whenever you told us October 2019.
Yes, a week before.
So they were probably registered in relation to potential sexual harm and other things. I don't know, they're different categories. Yes. So the family must have worked up to October 2019 to get to that equilibrium. And there's no child protection plan in place, no local authority intervention, save perhaps soft assistance to the family in the preamble up to this November 2019. So I know you're stressing the negatives of the history, and that's fine.
Yes.
And there's a long, long history.
Yes.
But there also was a period of obvious cooperative working,
there was,
which led to taking the children off the CPR and the trust or the local authority ceasing any intervention.
Indeed. And indeed, and His Honour Judge McPhee sets out repeatedly the positives, both of the historical working, because importantly, the local authority acknowledged that in one sense, in In a general sense, engagement with the family wasn't necessarily the problem. It was the depth and effect of that engagement. That was the concern. So the family would allow people in. There were conversations, there were meetings, there was engagement at that level. And for clearly a long period, that bumbled along, being seemingly broadly acceptable, in fact improving to the point at which it felt, in terms of safeguarding and the way that the family were operating, it was sufficient to step back significantly. Unfortunately, that does cut both ways. It's impossible to know whether there was therefore a subsisting risk during all that, and whether that only came to light because of the circumstances of A presenting almost literally on the doorstep in November 19, and how the family responded, because despite all the work, and you'll have seen various references in the judgment and the various documents that were produced for the judge, the family were saying, look, we've done 20 years of work. The social workers were saying there's been over a decade of work here and it hasn't made any difference. The insight hasn't changed. We can't be confident the same mistaken judgments and decisions will be made by this family. So yes, it was balanced, and with respect, the judge balanced those matters out.
But the criticism by Lord Justice Peter Jackson that you've focused on is that the judge did not even mention the point that the combination of non-molestation orders, etc., had kept them safe. You focused on the word had coincided. I think Lord Justice Peter Jackson, on a fair reading, would be saying it's hard to think that's a coincidence.
Yes. Well,
but the essential point is the judge didn't even look at this.
Well, certainly
as far as we know.
The judge did not explicitly say, if you put together a supervision order and a non-molestation order, where does that leave me? He didn't say that. I can't pretend that that's there. It isn't. What is clear, however, though, is that the judge, in ultimately deciding against a supervision order, any kind of order at home, was fortified by a range of expert views about what the parents would have to be able to do for any order at home. Because any order at home requires the parents to behave in a certain way. And it was quite clear from the assessments of all the professionals in this case, and the judge's own evaluation, having heard the family's evidence. So it's not simply a professional dispassionate view. It's hearing and seeing this family, the whites of their eyes, and saying, I'm worried. There's a blind spot here. And
yes, I understand that, but a non-molestation order is directed at A.
Yes.
The fact that the family, in a sense, you might say, it's not to do with what the parents can do. A is now going to be committing a criminal offence if he breaks that non-molestation order.
I certainly think
and that is a factor that I can't see any reference to that.
There isn't reference to that. However, the idea of relying upon A, given everything that's known about how chaotic and how uncertain his circumstances were, and how reliable it could be that A would, the mere fact of an order that in its legal form forbade certain things, could be relied upon. And that was also in the context not only of a professional view of whether work, therapy, whatever one wanted to call it, could be undertaken with this family and be effective, and the views are set out in our document very explicitly there, but also the comments that were being made, particularly by Mother, in relation to A, both to Dr. Friedman and to Miss Ansell in the sibling assessment. It's quite clear that she's saying at times, I think C, who is upset in many ways and having a difficult time, would benefit from seeing A. She's saying, I don't know what to do when some of my daughters say they want to see A. And under cross-examination, and I've put this in the footnote of our document, and I can give a page reference in due course, but it's page 197. Under cross-examination, I said, well, what would you do if they want to see? And she said, well, I'll go with their views. So the idea, my lord.
That's all right, and you're quite correct, of course, that Dr. Friedman expressed the view that Mother didn't have it in her to change her relationship with A sufficiently. But wouldn't you have expected a judge to be saying to himself, and indeed to be saying in his judgment, what is going to be the effect if Mother knows, even whether she'll accept the judgment or not is a different question, but if she knows that these children are going to be taken away if she doesn't conform?
It may be that that was one possibility the judge could have dealt with that in that way. With respect, though, in the context of proceedings and child protection matters going on for so many years, the idea that there'd be yet another, if you like, warning, my lord, if you don't get it right this time, this is what could happen. The experts...
It's not what could happen.
Yes, what would.
Especially if there were a care order.
The difficulty is that some of these matters were coming out during the course of these proceedings. There wasn't an openness about the nature of this risk. It wasn't, let's all work together and try and sort it out. Things were discovered literally during the hearing by some people, particularly it seems, obvious risk posed by F2 and the risk that was taken in 2017. That simply wasn't shared. It wasn't known about. So this was, if one can put it like that, an underground risk. It was bubbling along and one doesn't know when it's going to burst forth in a catastrophic way.
Shall we continue this discussion after the short adjournment?
Thank you, Madam.
The court will now adjourn.